ConAgra Incorporated versus McCain Food Proprietary Limited was a legal battle between two large frozen food manufacturers over the use of the trademark Healthy Choice. To provide some context of the case, ConAgra is a large US-based food conglomerate that at the time produced frozen foods for a predominantly US market, with a market share of just under 10%. McCain Goods is an Australian subsidiary of a Canadian company which at the time had a market share of just over 20%. ConAgra had, prior to the case, in 1987, come up with the idea of a low cholesterol, low fat, and low sodium frozen meal to go by the name of Healthy Choice. The product line was a large success, with brand awareness at the time of the case in 1991 at just under 50% of the US public. ConAgra, despite some abandoned plans to move into the region, had no presence in Australia. After deciding to move into this market of a diet-restricted frozen meal, McCain executives noticed, liked, and took samples of the ConAgra product, telling others to take notice of this one. Items of particular interest were the green background and descriptions of low cholesterol, low fat, and low sodium. Using this, McCain applied for the trademark Healthy Choice in conjunction with their own logo for use in Australia. Within 2 months of product launch, ConAgra had commenced proceedings in the federal court under the tort of passing off and 2 sections of the Trade Practices Act. The primary legal issues raised in both this initial case and the following appeal was A. Whether there is a requirement of local activities, being Australian activities, to maintain a claim of passing off, and B. The effect of fraudulent intent on an action of passing off. In the first case, a single justice of the federal court sided in favour of McCain in the matter of the passing off claim and one of the claims under the Trade Practices Act. The justice did, however, favour ConAgra in the matter with regard to Section 52 of the Trade Practices Act and a trade presenter which had been disseminated among suppliers. ConAgra appealed this result to the full court, and McCain cross-appealed with regards to the trade presenter. The following judgment is one of the leading authorities on passing off and provided the current approach when considering international reputation and its effect on a claim. Justice Lockhart in the appeal case defined passing off as an action that stops persons and companies gaining commercial advantage through wrongfully taking the attributes of another business. This action requires the satisfaction of 3 elements. 1. Reputation, 2. Misrepresentation, and 3. Damage. The first of these elements was the primary concern. The full court considered extensively the case law of other jurisdictions before settling on a decision that acknowledged that whilst there is no necessity of a physical manifestation of the business in a country, its reputation must be substantial enough to create special meaning in the trademark, in this case, Healthy Choice. Their Honours decided that some 2,500 magazines with advertisements and the tangential impact of holiday goers, both to and from the US, did not create a big enough reputation in the Australian market to create this special meaning and reputation. The issue of fraudulent intention was dealt with by the justices as secondary to the reputation of the company defrauded. Whilst the fraudulent, near-blatant copying of ConAgra's trademark was acknowledged, Their Honour suggested that this would only provide increased remedies where there were remedies available, but not create one in its absence. Due to lack of reputation already precluding ConAgra to a remedy, McCain's fraudulent intention had no effect on the results of the case. In the end, the appeal of the federal court decision was dismissed on all grounds, as was the cross-appeal. Their Honours decided that the primary justice had not erred in suggesting that the lack of business or reputation in Australia precluded ConAgra from claiming under passing off, and that there was no special meaning attached to the words Healthy Choice to provide any remedy under the Trade Practices Act. Likewise, the court decided that the primary judge had been correct in finding that such a special meaning did exist in the niche category of food suppliers, and hence the trade presenter was in breach of Section 52 of the Trade Practices Act.